Members of the jury, you should not believe a witness merely because he is a disinterested witness. That is, one that has no apparent interest as a witness. In effect, it is for you ultimately to determine how much credibility should be given to a witness. The mere fact that witnesses come before you as police officers or public officials should not affect your determination as to the credibility of said witnesses. Their testimony does not deserve either greater or lesser believability simply because of their official status. Whether you do or do not believe any witness must depend upon how truthful you judge the witness to be. It is quite legitimate for counsel to attack the credibility of a police officer or any other witness on the ground that his testimony might be colored by personal or professional interest. If you find any conflicting testimony and you can consistently reconcile testimony, it is your duty to do so. Let me repeat. Whenever you can consistently reconcile conflicting testimony, it is your duty to do so. This is because human experience has taught all of us that often persons seeing the same event at the same time may not be able to describe it in the same way, and that is the reason for this ruling of law. But where you find any conflict of testimony that you cannot reconcile, do not hesitate to cast aside that which you deem is exaggerated, incorrect, or willfully perverted, and accept that which you believe to be correct and truthful. If you find that any witness in this case has willfully testified falsely to a material fact, you may, if you so desire, disregard the entire testimony of that witness, or you may take so much of his testimony as you believe to be true and disregard the rest. The defendants, by their plea of not guilty, come before you cloaked by the law with the presumption of innocence in their favor. They are coming here for trial. They are presumed to be innocent, and that presumption continues right through the trial and exists right now and accompanies you into the jury room. That presumption is always there, and the only way it can be destroyed is by all 12 of you agreeing on the basis of the credible evidence that the defendant is guilty. You cannot find the defendants, either of them or both of them, guilty by first discarding the presumption by saying or feeling, well, they must be guilty. No, you must first start by saying that they must be presumed innocent, and only after the start of the evidence which you accept and believe convinces you beyond a reasonable doubt that the presumption must be disregarded and the verdict of guilty then returns. Only then is that presumption destroyed. The burden of proving the guilt of the defendants rests at all times upon the prosecution. Under our law, the defendant is not obliged to prove his innocence. Before you find a defendant to be guilty, you must be convinced that each and every element in the crimes charged and the count submitted to you and that defendant's guilt had been established beyond a reasonable doubt. Credible evidence, which is evenly balanced, is naturally not beyond a reasonable doubt, and in that case, a defendant must be acquitted. The evidence in this case is the oral testimony of the witnesses and the exhibits admitted into evidence during the trial, not the summations of the district attorney and not the summations of either of the defendant's attorneys. As I have said, the prosecution has the burden of proving the guilt of the defendants beyond a reasonable doubt by the credible evidence. If the facts as established in this case at this trial are equally susceptible to two inferences, one of which is consistent with innocence and one of which is consistent with guilt, the law states under those circumstances you must accept the inference of innocence and acquit the defendant. Now we come to the very important definition of reasonable doubt. Fortunately for us, our United States Supreme Court has gone through the trouble of defining reasonable doubt, and I am going to read it for you. I quote, "A reasonable doubt is an actual doubt that the jury is conscious of having after going over in their minds the entire evidence in the case, giving consideration to all the testimony and to each and every part thereof. If then you feel uncertain